I give the floor to the representative of Djibouti.
Merci, Monsieur le Président. Djibouti félicite la distinguée délégation de la Pologne pour la tenue de cet important débat ouvert sur une question cruciale, respect du droit international dans le contexte du maintien de la paix et de la sécurité internationale. L'actualité sanglante de ces derniers jours démontre, si besoin est, la dimension vitale du respect du droit international. Sous le prétexte fallacieux de la légitime défense, Israël a systématiquement eu recours à l'usage de la force brutale et excessive, violé systématiquement et impunément le droit international et les droits humains des Palestiniens. Nous exprimons notre profonde gratitude à nos briefers. Nous avons une pensée particulière pour M. Isashi Owada, juge à la Cour internationale de justice, qui va bientôt tirer sa révérence après de longues et fructueuses années au service de la promotion du droit international. Nous saluons son dévouement et lui réitérons nos meilleurs vœux pour l'avenir. Mr. President, consistency and full implementation of United Nations Security Council resolutions is critical in the maintenance of international peace and security. Regrettably, Eritrea, a neighboring country, continues to cynically defy all United Nations Security Council resolutions. My country continues to face the threat to international peace and security that has been created by the unlawful use of force against Djibouti by Eritrea, the occupation of Djiboutian territory by Eritrean military personnel, and the refusal of Eritrea to account for Djibouti prisoners of war captured in 2008. Threats of force continue to emanate from the Eritrean side, and the risk of violent confrontation is once again high. There is an urgent need for a dispute settlement mechanism. It would be Djibouti's preference to have the dispute referred by mutual agreement to judicial settlement or arbitration. The result of either means of settlement would be a legally binding judgment or award based on international law, which would assure both parties of a fair process and equitable settlement that fully, finally, and permanently resolve the dispute. Mr. President, in response to your request to make specific contributions today, Djibouti would like to humbly submit the following observations. First, encouragement of disputing parties to submit the dispute for binding judicial or arbitral settlement. There is precedent for this. In 1947, the Security Council did so, and the court rendered the judgment that resolved the dispute. Remarkably, since then, the Security Council has been reluctant to encourage disputing states to submit the dispute to the ICJ or to arbitration. There's no good reason for such reluctance. Ironically, under the League of Nations, the Council frequently encouraged states to submit the dispute to the Permanent Court for International Justice, the predecessor of the ICJ. Some states on the Council might be reluctant to interfere with the principle of consent. Under this principle, no state may be compelled to submit to the jurisdiction of a court or arbitral tribunal without first giving its consent. This is in recognition that each state is sovereign. However, there's no reason to be concerned here. The Security Council will not be compelling any state to go to court or arbitration. It will be using its influence to get disputing states to consent to it. This is an effective means of resolving disputes that, left unresolved, constitute threats to international peace and security. Second, requesting the Secretary General to use his good offices to get the parties to agree to judicial settlement or arbitration. As an alternative to working directly with the disputing parties, the Security Council can request the intervention of the Secretary General and the use of his good offices to help the disputing parties agree on settlement of the dispute by one of the means listed in Article 33, including judicial settlement or arbitration. More use could be made of the good offices of the Secretary General for sure. Third, greater use of the ICJ's advisory jurisdiction. On numerous occasions, the General Assembly has requested the ICJ to issue advisory opinions on the legal aspects of dispute with the objective of assisting UNGA in exercising its role of promoting peaceful settlement. The Security Council has requested an advisory opinion from the court on only one occasion. Nevertheless, this is an important precedent. The Council could make greater use of its power to request advisory opinions in order to promote peaceful dispute settlement in accordance with international law. Fourth, encouragement of ratification of international human rights and humanitarian human rights treaties without reservations. Participation in the world's most important human rights and humanitarian treaties is still not universal. A number of states still have not ratified major conventions or have ratified them subject to reservations, excluding themselves from the treaty's dispute settlement provisions. The Security Council could engage in a campaign to achieve universal acceptance of these treaties and to encourage states not to exclude themselves from the dispute settlement provisions or to encourage states that have already excluded themselves to remove their reservations. These treaties include the Convention Against Genocide, the Convention Against Torture, the Convention Against All Forms of Racial Discrimination, Convention on the Status of Refugees, Conventions Against All Forms of Discrimination Against Women, etc. Fifth, promotion of judicial recourse under international human rights and humanitarian rights treaties, where a state responsible for horrendous human rights abuses, such as Myanmar in its campaign against its Muslim Rohingya population, Security Council could consider encouraging one or more states which are parties to the same conventions as Myanmar to invoke their rights under the dispute settlement provisions of the conventions to bring Myanmar before an international court or arbitral tribunal. Sixth and last, encouragement of states to accept the jurisdiction of the ICJ. More than 70 states have submitted declarations voluntarily accepting the jurisdiction of the ICJ under its so-called optional clause, Article 36, Paragraph 2, vis-à-vis other states that have made similar declarations. This is still a minority of states, however. Security Council could encourage other states to accept the cursed jurisdiction. This would not violate the principle of consent because there would be no compulsion, and submission to the cursed jurisdictions would be entirely voluntary. Thank you so much.
I thank the representative of Djibouti for his statement and